All right, moving right along. We are now going to just do a sort of an overview of what we had learned through the series on statute of uses. And what I had done was write down some predominant features I thought were important to cover. And so we can get past this point and then move on to the sesquiquy viax. Okay. So originally we were talking about the foundational principles after AD 1066 of William the Conqueror, or William the Purchaser, based on the feudal land tenure system, and whereby all land rights achieved to the king as divine ruler. Uses were understood by means of the Roman Church. This Roman Church, they introduced the use because they were not seen in the common law. The Roman Church, being a corporation, could not affect rights to the common law. You've maybe heard that when a monk, in order to be ordained a monk, you are now civilly dead in law. Again, you moved into the corporation. Barons, aka tenants-in-chief, had secured their rights through bloodline. They are the ones that hold the predominant manor immediately subject to the king. Lord subject to baron, so immediately or secondary to the king, began transferring into the church their portions of their land to avoid common law fees and incidents. Practice stopped originally through the advance in the Magna Charta, and next through Edward's first reign in 1290, titled Law of Mortmain, which, before land could be transferred into the church, it had to go through the right granted from the king. So the king had to give it his seal in order for a lord to move it into the church. Okay, and so as that was now suppressed, man being what he is, he found new means in which to circumvent the common law. So they began to transfer their legal titles into joint tenants, okay, through feoffments, it was called. And these tenants, joint tenants, were called feoffees. This created a use which was not seen in the common law, and it circumvented again the interest of king was right, who had a right immediately too, and not which those values, those incidents that were ordained through the right that the Lord held, subject to his title. Courts of chancery evolved because of the disturbances the kingdom was experiencing, which could not be heard in the common law court because it's a different subject matter. It's a use not recognized as it's a equitable interest or a beneficial interest which is not recognized in common law. The conscience of the king traveled into these manor courts to hear matters pertaining to the agreement first created by the feudal tenant before he transferred his legal title into these joint tenants or to these feoffees. So that evolved through the bishop being the Lord Chancellor, who then traveled to these independent courts, which were in these manors held by the baron, to which he could hear those rights or wishes that were first granted from the one who owned the original right, the Lord, who then transferred into these joint tenants, and these joint tenants not then doing as what was in the original agreement. At firstly, there was no rights, or the common law could not see this agreement, so there was no remedy. And as this progressed and this Lord Chancellor went in to hear about the agreements, we evolved into the rules of equity, known as equity law. Uses then were overused. We see over and over the same thing in history. We get to a point of hierarchy of greed, and then we get or every empire sooner or later has to be dissolved and start again from another point that evolved from all of this overuse of anything. It's just, I think somebody said that exousis, which the ancient Greek, and of course I'm bastardizing that pronunciation in Greek, but exis or exis, it sounds like 666, the greed in man, right? So again, uses then were overused, whereby rights to an interest in land was not secured through surety of the title. So the title, just if you purchased a title, you weren't sure whether that title was would be held against any others that might be before it, who can then come in and say, oh, I'm taking over, or of the interest held before your title, and therefore I'm eliminating your title and I'm moving it to somewhere else, or do whatever. So there was a lot of uncertainty, of course, created through that. No one knew if their title was actually of any value to be seen in the courts, of equity, of course. Fraud started to be witnessed through secret fiofments. The Sesquici use were preferred to the common law legal estates because they became predominant, because it was that point where the Lord could now held an interest in land that he could devise as he saw fit, whereby the barons and so forth and those laws in common law, it was strict. There was no wiggle room. Richard, the Duke of Gloucester, became successor to the throne, as known as Richard III, and so had to be relieved of his duties as fiafi to uses. So apparently he had fiofments that were, directly with the beneficiary, or the one of the use. Also, he had apparently fiofments with joint tenancy. So he had to be relieved of those before he could accept the crown, and accept the throne. So he had to, in order for it to be done legally, it had to go through Parliament to create the statute, and see the transfer had to be done where what he was holding, if it wasn't with the joint tenancies, because of joint tenancies he could just be removed and it would go on, but where he had an interest directly associated with, as an independent, with that beneficiary, and he had to give that title he held back into the beneficiary. So thereby you can see the beginnings of the statute of uses, where it executed the use, eliminated the use, inasmuch as that one who was a beneficiary before now became known as the one who held a legal estate, therefore was subject to the incidents that he was before circumventing through creating the use in the first place. The statute created to move the legal title back into the use, the beneficiary. Sorry, just went through that. Henry VIII, now we move into Henry VIII, was drowning in debt, needing a means in which to generate revenue so as to fill his purse. Taxation was always unpopular, and it also more unpopular because it represented the king's own inability to properly spend the wealth of the kingdom. So in his own ability to properly manage what was before given to him by his predecessor, I think it was King Henry VII, I'm not sure, and he depleted those coffers quite readily through his means in which he felt to spend it, and so he needed a means in which to replenish those coffers. So Henry, instead of looking through taxation, he targeted the common law and the use, as it was not yet settled. It took 3 times for him to pass through Parliament the use, or the statute of uses, which we are commonly known as the statute of uses 1535. The statute of uses 1535 created a new title to be seen in the common law, so therefore now it created a scission within a before beneficiary, to which we've already said and covered through the knowledge of which Richard III had to do was be relieved, and he moved his title back into the beneficiary, creating a new title of use, to which now the statute of uses could see it now in common law. Okay, so it just changed the byproduct of what Richard III did by creating an actual statute that recognized that transfer to that one who was before a beneficial user to now be held with a legal estate, to which now could be dealt with in the common law. Okay, and it was which executed the use, and through the removal of the theophy to the use. Okay, said to be the vector point of the modern day trust, and through the status of who held the interest and how that interest was held. Some say the purpose was actually by notice of the use now having a legal estate and so held in the incident associated with the land interest was actually a means in which to create a new power in order to devise land, where it was again it was not seen in the common law. And some scholars and people that have discussed the statute had said in so much that it was to execute the use and get rid of the use, where this other people say, well, no, actually what it was done was to create a new power of the use to be seen in common law that can help more efficiently devise lands. And I align with that. I align that that's what common law had to look as things progressed and trade was more easily accessible, and there's more action going on within that society, that we had to find ways in which to start maybe abolishing the idea of slavery and giving rights to people over time, to which then align with the natural law, whereby the natural law noticed the dominion rights and a man's will cannot be oversought or overreached by the means of slavery and involuntary servitude. It had to reach that crescendo where it noticed that man who created the titles had to always be first in order for it to be lawful. And up to that time, being a despotic monarchy, it was still under involuntary servitude and slavery. And even if you say the barons had accepted their rights to manage or administrate over a manor, it still was under the right of the king who gave it to them. So there was that sort of do this or you're cut out in left field or you're losing everything. So there was still a manageable sort of a means. You didn't really had a choice. You still were a tenant. You didn't have a choice to manage that land how you see fit in order to devise it by your own will. You were subject to strict laws that evolved from AD 1066. So that's pretty much it. I hope that was a good overview, and now we can look into I think the Sesquiqui Acts of 1540 and 1707, and to really get a handle on how things have evolved to where we are now subject, if you're a citizen and subject to a trust for sale, subject to those equitable interests that have evolved through sort of the subinfeudation process of a use upon a use, to which now a citizen through purchase is at a third level of use, whereby today we're witnessing that move into the fourth level, and they just call it the fourth industrial revolution. With that, have yourself a wonderful day.